have a duty to protect the members from the arch-bully in OO. You know, his bullying is very infectious. It even affects the Land Attorney General in trying to bully the Honorable Jonathan. But I'm happy that he's now under your full control. So allow me to make very humble submissions. You see how he's looking at me? Yeah, he's really pointing at me. So you'll have to protect us from the arch-bully in the minister, that we do our job well. My shoes are brown, please, and they don't have the shape of...
to look at me and not the members submitting. Is that possible, isn't it?
Yeah, let him look at you, and I will
You should smile.
I have a few issues to bring to the attention of both the Minister and the Land Attorney General. I went through this bill over last evening and this morning, trying to find where to press the new provisions in line with the command of Article 129D. I have tried to establish, with all the voluminous presentations, how then you have the court martial becoming a court. I can't find it, save for the words here enshrined. I was trying to cross them into the law as it's known. Would the Land Attorney General advise me how these amendments fall within Article 129(1), so that eventually we can see the court martial becoming a court? Because the ruling, Supreme Court ruling, which has been deemed as advisory and therefore motivating over these amendments, was very clear on what makes a court. And it's not merely personnel, it must also be existing within the law, and the law is Article 129. I want the Land Attorney to help me place these amendments, because I'll give you an example, Honorable Chair and colleagues. When the ICD was being formed as a branch of the High Court, the International Criminal Court, Criminal Division of the High Court, clearly the parameters that formed it were clearly under Article 129 and was deemed the High Court. The amendment so provided by the Land Attorney General and the Minister, for me, still contradict what the Supreme Court actually guided about. And at no one time did I envisage the ruling as advising the military or the minister to go and try to be creative and even try to strip civilians of their status and bring them in under the ambit of the military to sort that ruling. It never was the objective, because you need to understand, Honorable Chair, the ruling of the Supreme Court is almost enacted law. It never at any time will empower government to go and strip civilians of their status for the sake of conveniently trying them in the military courts. That was not the objective. The objective was to strengthen Article 28, which talks about a fair hearing. That's why throughout the thread of this ruling, there is reference to Article 28, 1, I think, D, and Article 44C. None of these amendments, and I'm here to wait to be convinced, speaks about that when you have these amendments, therefore you'll have a fair hearing. Therefore you'll have a speedy trial. You'll have, fair presentation. Honorable Chair, I want to be convinced that these amendments actually speak to the command of Article 28 and 44C. Otherwise, taking them on face value would mean that the UPDF Act is now the supreme law of the land, and the Constitution is subordinate to the UPDF Act. Honorable Chair, the exceptional circumstances and whereas the ruling spoke about the fact that all these cases referred to as exceptional circumstances can be tried in civilian courts, and indeed they can be tried in civilian courts, I have not seen these amendments speak to the fact that the civilian courts are inadequate in trying these matters, and therefore their warranty being taken to the court martial. These amendments are not stripping over that fact and are not introducing anything new to warranty exceptional circumstances. Honorable Chair, the lawyer in you, the advocate in you knows so well that murder, cat rustling, and all these cases can be ably tried in High Court and the entire appearance system of the courts of record. So where is this coming from? Isn't the minister trying to impute ill motive on the part of the Supreme Court in using their ruling to say they were given room to override the Constitution in bringing these amendments? Because I have been carefully trying to see where is the gap, where is that lacuna they're trying to cure. I cannot trace it. So, Honorable Chair, for me, I am not sentimental, I'm not emotional. I am tracing for what the Constitution says, and where the Constitution commands, I am obliged to obey. I am failing, and I'm failing to say a single clause that makes the court martial a court throughout these proposals. Not improving the personnel to say, as long as the personnel is, the chairperson is an advocate of the High Court, that cannot turn it into a court. Otherwise, I'll sit here and turn you into a court because you're an advocate, so am I, so several others, with Mr. Chuanaka, yourself, Senior Abdul Katuntu, and you say, as long as Katuntu has served for 25 years, yours is now a justice of the Court of Appeal, will become part of, so it's not a question of qualification, it's not a question of service, it's a question of the Constitution, Honorable Chair. I am waiting for that single statement here that confirms that these amendments have changed the command of the Constitution in what is a court. Thank you.
The public must attend to Parliament today. I came to seek your clarification, but also request this committee. Now that matters in this bill concern the general public, because whereas the Supreme Court ruled that civilians are not supposed to be tried in military courts, and the bill is hell-bent to bring back the same, Chair, I want to plead with your committee that you give ample time to the general public to come and express their views, because most of them could have missed the advert the way I could have missed it had it been not my voter who picked it. So that's my request to the committee. It's my request to the minister. Do not put UPDF. UPDF is an institution for the people of Uganda. Whenever it is put against the people of Uganda, it becomes very dangerous. Whenever things like this come and people are not given chance, Mr. Chair, it will be very dangerous. So I am pleading with you on this. Secondly, I minister, and I was ready to clap for him. had he stated clearly why he still insists on bringing a matter where the Supreme Court had a ruling that civilians are not supposed to be tried in court martial. I was willing to clap for him, unless, unfortunately, he wanted to be clapped for other reasons that were not, we wanted to hear that. Why the bill is still insisting on a matter where we have a court ruling. And lastly, Chair, my brother, the Honorable Katuntu, highlighted somewhere that, you know, civilians can be tried or may be tried if they are found with weapons. And this is where we need very big clarity, Chair, in this bill. We have situations where the military have planted weapons in people's homes, civilians' homes. They have planted them. They have planted these, what they call military attires and everything. They plant it in your home. They arrest you today. They, after arresting you, they take you to your home, and they themselves, they know where the weapon is. So how are we going to deal with that? Because it has been a problem. I'm a civilian, Patrick Insamba, I've never held a gun. Tomorrow they find a gun in my home, planted by the same military. It becomes a very big challenge, and this law must come very clear on that. Then the one last bit. The military always has come out to claim our attires. I come from National Unity Platform. One day I picked my beret and gave it to a military officer. Say, put on this one. The military officer told me that is not ours, because ours is different. And what differentiated it is the emblem that is there. So even here, it must come out clearly in the law to state that the color and the emblem that is put there, not only the color, to say that color blue or color red. Thank you very much, Mr. Chairman.
One, are they high court judges? Where is the privileges framework as the extension of security and independence?
Thank you very much.
Bill is concerned, something which is important to administration, especially at the point of sanctioning files, because he has, I think these judicial officers should be given security than to give them a timeline that you are, for independence purposes, that the contract can be for 5 years. If you are a judge, you can only administer justice when you are sure that issue should also be revisited, and whoever works in court martial, if he's a judge, his security of tenure should be as the security of tenure in the Honorable Attorney General. There is this case of Second Lieutenant Ogwanga Ambrose, when you have taken the route of when you have been prosecuted in court martial, that you cannot now shift to the civil courts. I'm inquiring whether this clause.
I think we need to just go back and review what we are thinking about. But I think the law is talking about similar. That if I looked at it from a distance, what would I think that person is? If, for example, a person is running out of this building, putting on this uniform, wouldn't you ordinarily think that is for the soldier? That is where it is supposed to avoid confusion. So if you have a red beret like you have for NUP, if you're in a crowd, a person looking at you at a distance, would they think it is NUP or military police? That's the issue. So when the law is looking at those issues, it is looking at about the similarity and likely to confuse. Obviously, there will be extensions where we are discussing black shoes. So that is the comment on that. But I think that is a policy issue we need to look at and understand how can we best, what is it that we would look at as contradicting what the army uniform would be. And Honorable, the question of framing is criminal in itself. So, but that is another matter. If they are framing someone and putting a material in their house, that's criminal in itself. So we try to write a law, but we write the law for human beings. Human beings, by their nature, we try as much as possible, but they are going to fail in certain instances. That's why you have the laws. So it is that framing is definitely criminal, and we need to address it. And I think it's for us to think about what kind of safeguards can be put in place on both sides as Parliament. What safeguards can be put in place to ensure we address that issue. On the issue of Ogwang that Honorable Abdallah raised, yes, in that case, the court faulted the use of appeal as made by an instrument signed by the minister. The court said in the Ogwang decision that a minister cannot vest jurisdiction of appeal by an instrument. Jurisdiction of a court is vested by Parliament through principal legislation. So by bringing this here, we are asking Parliament to grant the principal jurisdiction not by statutory instrument, by principal legislation. So yes, it would be curing that. On the security of tenure, we discussed it and we can continue discussing it. The Army has a challenge on the stages of retirement, which are not necessarily the same as ours in the civilian life. In civilian life, we say a judge will retire at 65, and that person leaves the public service. But in the Army, people live at different stages of life. So some people live at 45, others at 50, others at 55, others at 60. So if you say that the person shall retire from the service of the court martial at, say, the age of 60, that person may be way past the stage of their retirement, but that's a consideration we could have. On your recommendation to have the DPP participate in prosecution, that would contravene Article 1, Honorable Abdallah. You had proposed that we have the DPP sanction the charges under the court martial. And I was saying that would require a constitutional amendment, because the Constitution under Article 123B specifically prohibits the participation of the DPP in matters before the court martial. Honorable Abdul Katuntu raised a number of issues. I'm going to leave the issue of the monopoly of the Army and etc. to the experts in these weapons. But what I know is that for the AK-47 to be used by police, it needs to get permission from the Army. That I know from my interaction with them. For prisons, even private firms to use AK-47s must get the permission of the Army. So, but they are here, they will be able to explain to you how that works. Then on competing jurisdiction, I see what you're saying. I think the only difference here is that if I have a firearm lawfully and I shoot someone using that firearm, and I shoot someone and injure someone, there is no question of me going to the court martial. It doesn't exist, because I have the firearm lawfully, but I've committed an illegality with that firearm. Yeah. Yes. Now that unlawful possession of the firearm would be charged by the court martial. But if you murder, if you look at the law, if you have an unlawful firearm as an individual, and you go and commit murder without the assistance of a serving officer, you have the firearm illegally, you go and commit murder using it, that you will be charged in the court martial for that unlawful possession of that firearm. So if you have it lawfully and you use it for an unlawful act, you will be tried by the civilian courts. Why? Because at least you made the effort to go and report yourself that I have a gun. So that is other thing. Now, on parallel jurisdiction, I think the issue would be you can be tried in both places. And that happens in many instances. You can be tried in both places, but I think the issue is that both of them have jurisdiction. Both the High Court has jurisdiction over the murder you have committed, and the court-martial has. The issue that we have is that if you are in concert with a soldier, then the court-martial also has jurisdiction. Now the problem we are having is that if you take the soldier the other side to be tried in the court-martial, and you take the civilian this side, the trial of those. Yeah. In two different places, yes. So the issue of possession of the firearm and the detail of it is what I'll leave to the experts. Because some experts sent me here, that, like for example, there is a bayonet which is attached to the gun. That bayonet which is attached to the gun, they're not expecting you to find it in a shop roaming around with it. That bayonet is the preserve of the army. So, but they'll give you more detail.